Hello and welcome to the last video on the A.K. Gopalan judgment, and in this one we will look at a short analysis of what was held, what was the impact, and all of the things that entailed, all the ramifications of this particular landmark judgment. But first of all, before we head on to that discussion, a quick look at why this particular judgment is considered a landmark one. And in future, over the next 2 years or so, when we intend to cover several of the Supreme Court's landmark judgments and thus make our way through the history of our apex court, we will be looking for at least one, preferably several of these and many more such criteria to pick those cases, those judgments for discussion on the channel. The issues that are involved in the case, they should be significant enough, maybe constitutional, maybe not, but nonetheless significant enough. Or if fundamental rights are being commented upon by the Supreme Court in that particular judgment, if interpretation of the Constitution and its provisions is a part of the decision-making process of the Supreme Court, if any doctrines have been utilized or resorted to by the Supreme Court in order to arrive at a particular decision, if things such as judicial review have taken place in that, and there are several more such criteria. I am mentioning only these 5 over here because these are the ones that were encountered in the A.K. Gopalan case, the first ever fundamental rights case that came before the Supreme Court within months of the inauguration of our Constitution and therefore of the Supreme Court. The significant issue, of course, was that of preventive detention, as was quoted by Mr. Nambiar and several authorities before and since, that India happens to be probably the only free, democratic, liberal nation with a written constitution which allows for preventive detention in peace time. Preventive detention during wartime is perhaps excusable, almost expected. For example, in India itself, we saw in one of the previous videos how the British government had enacted the Defense of India rules during the First World War and during the Second World War. But during peacetime, when the British government actually resorted to a similar policy in 1919, the Rowlatt Act, we might recall what the reaction was of our freedom fighters, that we had helped the British in its war effort in the First World War, and the fruit of that help was that lawless act, as it was called by the Congress freedom fighters in 1919, and everything that came along with it, including Jallianwala Bagh. All of that makes it further difficult to swallow, makes this particular Preventive Detention Act of 1950 that much more difficult to swallow. So the A.K. Gopalan case, therefore, was an opportunity afforded to the Supreme Court of India to remove India from this particular infamous list, right? It's not exactly a list to be proud of, countries which have peacetime preventive detention available as a form of arrest for the state government, for the state authorities. And this particular notoriety that India perhaps would have gained, there was an opportunity for the Supreme Court to get rid of this, but they did not do it. They allowed the statute to continue, except for one provision of which was anyway extremely unpalatable, that the Parliament itself had attempted to amend it. This judgment then has been widely criticized by most constitutional scholars. Of all the ones that I have referred to during the creation of these videos, as well as over the years as a lawyer and before that as a law student, the only authority that I have found who has not criticized and has almost praised the A.K. Gopalan judgment is Mr. H.M. Sirvai, the Advocate General of Maharashtra. So you might almost call him a part of the state, and therefore it is not perhaps surprising that he has not criticized the judgment. Just about every book that you will read, just about every reference that you will encounter has invariably criticized this judgment. What was more unfortunate was that the court did not have an occasion to overrule its own finding in A.K. Gopalan for almost 30 more years. It was only in 1978 when the Menaka Gandhi case came before the Supreme Court, and it was actually not seemingly as far-reaching a case initially when it came before the court as A.K. Gopalan was. Nonetheless, the Supreme Court, having lived through almost 28 years of executive tyranny in certain occasions, and including the emergency, what some people refer to as the phony emergency of 1975. After all of that, the court finally had enough. But for those 28 years, Article 21 was rendered pretty toothless by the A.K. Gopalan judgment. This is described very nicely by one of our favorite constitutional scholars, M.P. Jain, in his brilliant authoritative tome, Indian Constitutional Law. He criticizes the A.K. Gopalan judgment as something which denuded Article 21 of much of its efficacy and effectiveness, and made personal liberty a matter of legislative discretion, which it would have been even in the absence of Article 21. Now, this is a brilliant point. The point of Article 21, the point of fundamental rights, the point of Part 3 of the Constitution is that those rights are fundamental, they are transcendental, they cannot be removed. They exist as human rights because we were born as human beings, and the very fact that we were born implies that we possess those particular rights. According to the A.K. Gopalan judgment, on the other hand, the right to personal liberty is entirely dependent on whether or not the legislature allows us personal liberty or not. That is what it comes down to. Perhaps the court did not realize that that is what they were giving as an opinion. That is what they were deciding. This, unfortunately, was indeed the case. Personal liberty was entirely and in the hands of parliament or state legislatures. It was only the executive whose actions were now being scrutinized as per the court's interpretation of Article 21, making us wonder whether fundamental rights were fundamental at all. An even more interesting and perhaps more important opinion was given by Mr. K. Subbarao after his term as the Chief Justice. Mr. Subbarao who retired as the Chief Justice in 1967, just after he gave the famous Golaknath judgment, which we will eventually make our way to. A couple of years after that, Mr. Subbarao was invited to give the Sir Chimandlal Setalvad Law Lecture in Bombay, as it then was, and that lecture was published as a book in the year 1970, and I have taken this sentence from that book. The preponderance of view among the jurists is that A.K. Gopalan is wrongly decided. It has in effect destroyed one of the greatest of the fundamental rights, which is personal liberty. This is a scathing criticism by a future Chief Justice, a future after A.K. Gopalan, and past when he was making this statement. A person who has been the Chief Justice of India himself has criticized this case. In 1969, it took a further 8.5-9 years for the Supreme Court to actually find an opportunity and grasp that opportunity when the Menaka Gandhi case came along. But till then, we really were left wondering whether our fundamental rights were fundamental at all. How did the court end up making such a seemingly what we shall respectfully refer to as a blunder? Is because of its stance of interpreting the Constitution strictly. Now, these are two sentences from the opinion in the A.K. Gopalan judgment given by the Chief Justice, Mr. Hiralal J. Kisan Das Kanya. It has been pointed out to me, by the way, that in one of the previous videos, I have referred to him as Harilal Kanya. I apologize for that gaffe. The problem, I am guessing, has arrived because we had another Chief Justice later down the line, Mr. Madhukar Harilal Kanya, who is the nephew of Mr. Hiralal Kanya, and that is why I must have confused between the two while going in the flow, so I apologize for that. So Mr. Hiralal Kania, the Chief Justice, in his opinion in the A.K. Gopalan case, has said that the courts are not at liberty to declare an act void because, in their opinion, it is opposed to a spirit supposed to pervade the Constitution but not expressed in words. What the Honorable Chief Justice here is talking about is the differentiation between the letter of the law and the spirit of the law. And in my humble opinion, that differentiation is the entire point of the concept of spirit of the law. The very point, the very definition, the very meaning of the spirit of the law is that it is not present, not mentioned in the letter of the law. Goes on further, where the fundamental law has not limited the general powers conferred upon the legislature, we cannot declare a limitation under the notion of having discovered something in the spirit of the Constitution which is not even mentioned in the instrument. Again, I would beg to differ. The spirit of the Constitution is mentioned several places in the actual document, including in the preamble, where if justice and liberty and freedom and all of these concepts are spoken of even before we reach the actual Constitution articles, it is a bit difficult to swallow. Unfortunately, what the courts had decided to do, what the Supreme Court and its original bench had decided to do, was stick to a strict interpretation of the Constitution. They, of course, did not have the experience that future benches of our apex court and our high courts were going to have, where the executive and the legislature, in order to propagate the policies that they had arrived at, were willing to sacrifice some of our constitutional norms. And that is basically the reason why the interpretation of the Constitution was done so strictly. MP Jain, again, in an essay, The Supreme Court and Fundamental Rights, in the book 50 Years of the Supreme Court of India, edited by S.K. Verma and Kusum, I apologize for that typo. This is a book I have mentioned in the sources video, and it is a book that I will keep referring to over and over again. MP Jain in that essay mentions that the court has taken an extremely static, mechanical, literal and positivistic view of Article 21. By positivistic, he means that only when some actual law has been made does that particular provision come into question. Thus, Article 21 ceased to be a restriction on the legislature. It only constituted a restriction on the executive. So, Article 21, according to the court in the A.K. Gopalan judgment, basically does not prevent the legislature from passing a law which would otherwise seem to be violative of constitutional values. The only entity that was restricted by Article 21, according to the court in A.K. Gopalan, was the executive. The executive would be able to act only as per the laws passed by the legislature. That is all that Article 21 does, according to the Supreme Court in the A.K. Gopalan judgment, which of course is not the truth. It is the legislature and the executive both who should be restricted by the fundamental rights, as Article 13 speaks of. Anyway, not all was gloomy. There were certain important positive things that happened during the over the course of deciding A.K. Gopalan. One of them was that the Supreme Court bench agreed that in order to understand and interpret the words and the decisions made that have resulted in the Constitution, it would be important and it would be enlightening to refer to the debates of the Constituent Assembly. In this particular case, of course, the debates of the Constituent Assembly had been referred to show that the use of the due process of law phrase was up for consideration and then discarded. So it didn't work out in a positive way for those of us who were looking for a wider and a more liberal interpretation of the Constitution. But nonetheless, this particular principle was laid down. In this case, it was the first time that the court got an opportunity to lay down such a principle, and that opportunity was taken. Coming to doctrines, that of severability, which we have discussed in the previous couple of videos, This doctrine was utilized by the Supreme Court, and it is a doctrine that has been used even later on. One of my favorite Supreme Court judgments, Kyoto Holohan versus Zachiliu, in which a constitutional amendment itself would have been entirely discarded had the doctrine of severability not been available to the Supreme Court bench at that particular time. Another case that we will come to eventually. The doctrine of severability, of course, states that if a particular provision in an enactment is found to be ultra vires of the Constitution, then that provision, if we remove it, if we discard it, if we sever it from the rest of the enactment, will the enactment stand? If yes, then the entire enactment need not be found to be ultra vires, just that provision, which happened to be the case with Section 14 of the Preventive Detention Act 1950. The origins of the doctrine of severability can be found in the Constitution itself, although it is a well-known doctrine in jurisprudence. Even the Constituent Assembly has entered words to that effect in the Constitution. I'm looking at Article 13, Clause 2. Clause 1 also has this phrase, but Clause 2, I beg your pardon, is the one relevant to us right now. The state shall not make any law which takes away or abridges the rights conferred by this part, and any law made in contravention of this clause shall, to the extent of the contravention, be void. To the extent of the contravention is basically what we achieve by utilizing the doctrine of severability. You deploy this doctrine and you chop off, you cut off that particular part of the legislation. Like if you have, if you allow me to give an illustration from genetics, if you are aware that a particular gene is going to cause problems, you can just splice off that gene and it would not appear in the offspring, and you have thus created a more robust future generation. But anyway, when we read through 13.2 once again, we realize the mistake that has been made while deciding Gopalan. The state shall not make any law which takes away or abridges the rights conferred by this part. And yet the court allowed the state made law which abridged one of the most important, if not the most important, rights conferred by Part 3 of the Constitution. The other important significant thing that did happen in A.K. Gopalan was that for the first time the Supreme Court was able to exercise its power of judicial review. Article 32 grants this power, in fact grants this obligation on the Supreme Court. We have read this clause before. Clause 1 states the right to move the Supreme Court by appropriate proceedings for the enforcement of rights conferred by this part is guaranteed, and that can be for petitioning for a writ of habeas corpus, mandamus prohibition, quo warranto certiorari, etc. So these two clauses were utilized by the Supreme Court in this particular situation to hold Section 14 of the Preventive Detention Act 1950 to be ultra vires. Section 14, of course, allowed the state, whether the state government or the central government, any officer under it, to withhold the grounds for detention of a person. And that was, as I had mentioned, been criticized by one of the members of parliament, Mr. H.V. Kamath, had warned the government, had warned the Attorney General who was sitting in parliament during these discussions, that the court is going to find this unconstitutional. It is mentioned in a couple of books, especially Bailey's book, that Mr. Kamath had a whale of a time after this in future parliament sessions at the expense of the Attorney General when he found a way to point out this. Nonetheless, coming to the ramifications of the A.K. Gopalan decision, while the right to personal liberty appeared to have been suspended because of this decision, it didn't really turn out to be that way because the government is too busy doing other things. What immediately happened was that many other people had been detained under Section 14 of the Preventive Detention Act 1950, and all of these applied to the Supreme Court for release, for habeas corpus. Most of these petitions were heard by Mr. Meherchand Mahajan, who was the vacation judge of the Supreme Court. So this single judge bench was the one who had to do all the work, and Mr. Mahajan rose to the occasion. I believe I have mentioned this in a video before, where he cut off the lunch breaks and the end of day times, all of those, in order to mete out justice as early as possible. The senior journalist Inder Malhotra, award-winning, of course, having won the Lifetime Achievement Ramnath Goenka Award, he has written this in the essay Present at the Creation, another essay I have mentioned in a previous video. You can find this in the book Supreme But Not Infallible. He describes that one of the main impacts of the A.K. Gopalan decision was a spate of petitions in the apex court for the quashing of detention orders, because grounds of detention were either mala fide, fictitious, flimsy, or inadequate, and fairly frequently these led to the release of detainees considered to be dangerous by the executive. That was fortunately a positive impact. What about the act itself? It was supposed to cease to be in effect from the 1st of April 1951. Instead, meanwhile, even while A.K. Gopalan removed one section from the act, the rest of it was found to be valid, and the legislature, Parliament of India, amended and modified whatever they needed to in order to keep the act in force. In fact, the last time it was amended, section 1 clause 3, which stated that original end date, that kept on getting increased, put forward, until finally 31st December 1969 is the last amended date for the effect of that particular act, which is why we have the opportunity to recall this line from David Bailey's book. It was not the fortune of the Preventive Detention Act to be enacted to serve its allotted time and quietly fade into memory. It was found useful by the government, and so it continued in force. It was found wanting in parts by the Supreme Court, and so it was modified by the Parliament. This winds up our discussion on the A.K. Gopalan case, the first of our many landmark cases to be discussed on the Supreme Court Historian YouTube channel. I hope you join me for the future judgments. Thank you.